to introduce the justice a little differently with our visiting clerks coming in, so just starting from the farthest left.
Tom McMeans.
Melanie Diaz-Adoro.
Tyler Stockton.
I'm presiding Justice Zora.
I'm Justice Long.
I'm Justice Blackford.
And I'm Justice Furman.
Start oral argumentation.
May it please the court, my name is Bailey Furman, and to my left is my co-counsel Kate Reed. I would like to reserve 5 minutes for the rebuttal. I will be addressing issue 1. This states the commitment order failed to contain all of the necessary findings and evidence to support Harriet Spetz's involuntary commitment. My first point is that Harriet Spetz can meet her basic needs, therefore should not be involuntarily committed. Montana Code Annotated 53-21-126, Section D, says that basic needs includes food, clothing, shelter, health, or safety.
Counsel, doesn't she meet sub B here, though? Where she has caused self-injury to others or to herself. I mean, this woman is taking blood out of her own body in her own home. She stabbed people twice now. Don't we meet sub B?
So for the blood drawing, the statement of facts says that she safely drew her own blood. So there's no evidence that she caused more harm to herself. If one of the 4 criteria are not met, the person suffering from a mental illness may require commitment. Harriet had a home, could clothe herself, could feed herself, and kept safe and healthy while on proper medication. Montana Code Annotated 53-21-126, Section 1, Subsection A, states the court must find the person suffering from a mental disorder and that because of a mental disorder is substantially unable to provide for the person's own basic needs. She was able to substantially provide for her own basic needs until her medication went off the market. The commitment failed to contain all of the findings and evidence because Harriet could easily have been relieved if an alternate non-liquid or colored medication was offered or available. According to Montana Code Annotated 53-21-127, Section 21, Harriet was not substantially unable to provide for her own basic needs. Harriet was open-minded and compliant to alternatives. She willingly took 14 alternate medications, went to a therapist, and had a priest come to her house every weekend before the involuntary medication order. The court order involuntarily committing and treating Harriet lacked critical information. In the case Re-LLA P3D, the district court was erred in failing to provide a detailed statement of facts supporting its commitment to the order. In Harriet's case, the court was erred in failing to provide the same evidence. My second point is that under medication,
Counsel, can't we simply just imply the findings based upon the testimony at the hearing, right? Aren't they consistent? We have that in Re-LLA as well. Why can't we have a bare bones district court order that matches and finds substantially the only testimony? In fact, there wasn't conflicting testimony at the hearing, correct?
Can you restate that, please?
So we have an implied findings here, right? We have psychologists testifying at the hearing. There's no conflicting testimony. The psychologist said that she is mentally incompetent and unable to care for herself, etc., met the requirements of the statute. And the district court's order reflects that. Why can't we just imply the findings?
Well, so the findings of facts was too bare bones to be able to do that. It simply just said that 2 facilities could have accepted her, but there was no evidence that stated why they didn't accept her, and the state mental hospital was where she was being committed, and although they applied for her to go to the two other facilities, there was no evidence on why they couldn't accept her.
Counsel, it sounds like you're talking about least restrictive means at this point. Is that what we're talking about right now? Whether the district court should have at least presented in their findings of fact and conclusions of law more evidence about considering other facilities and why those facilities were found lacking?
Yes, I believe that is correct.
So to that point, though, why can't we imply from the testimony at the hearing that the district court's order is sufficient? Why can't we, based on the testimony at the hearing, which we have in the record, which matches and doesn't contradict the district court's order, why can't we imply that? Why can't we imply the sufficiency evidence?
Well, there is no evidence. It is too bare bones to be able to imply that.
So, counsel, if I'm understanding you correctly, you're suggesting that because the district court's order itself was so insufficient that we can't reach back into the fact pattern, reach back into the evidence that we have from the hearing and sort of supplement the final order? Isn't that what the implied findings doctrine is all about? Reaching back into the record to supplement the order that is insufficient?
Yes.
Okay.
My second point is that under medication, Harriet Spence was not an imminent threat to society or herself. Montana Code Annotated 5321-126, Section 4, subsection B, states, because of a mental disorder and through an act or omission, cause self-injury or injury to others. And C, because of a mental disorder, there is an imminent threat of injury to the respondent or to others because of the respondent's acts or omissions. Therefore, a correct application of this code would be required if Harriet was a predictable danger to society.
I mean, hasn't she stabbed 2 people?
She has attempted to there recently, and there's no evidence to show that she actually caused injury.
Excuse me, counsel. Didn't she lace a holy water with mace and then spray the cops?
Yes.
So isn't that a harm to the cops?
It could be considered that, yes. Although Harriet threatened people, she did not recently cause injury to others. The only reported injury was over 10 years ago when she was 14. Although she refused to take colored liquid medication, it is reasonable that she asked medical professionals for an alternative. Citizens may have occasions where they need alternate medications. For example, someone with allergies may have to request alternate medication to meet their needs. Also, when someone has a fear of needles, it is perfectly reasonable for them to ask for medication that doesn't use needles.
Excuse me, counsel, seeing to the fact that they've already explored about 14 other medications for her just to see if it's effective enough to work, can we really expect them to find an alternate for her when it has to do with the color of the medication or anything of that sort, when they can't even find anything effective as of yet?
It seems reasonable for another medication to be found because there was a medication at one point that was effective for her. So it seems as if it is able to.
Excuse me, just to follow up on that, that medication is off the market now because of its effects on osteoporosis.
Yes, it is off the market now. But I believe that there is a way to find another one because there has been one in the past. Harriet willingly took 14 alternate medications that appeared normal to her. None of these alternate medications had the same positive effect on her than her original medication that was taken off the market. It is quite reasonable for Harriet to request alternate medication to meet her needs. Professionals should be able to create medication that has the same effect on her as her original medication or alter her original medication. Without her medication, she could become an imminent threat to herself or others because her reasonable request could not be met. It was not her fault that her medication went off the market. The medical system simply took that off, and that wasn't because of her mental disorder or anything. I believe it is necessary to bring up the fact that she cut herself and drew her own blood, but this was researched cutting, and she believed she was protecting herself through this. And the statement of facts says that she safely drew her own blood.
What guarantee do we have that she's not, at some future point, when she doesn't have access to needles and other equipment that will allow her to safely draw her own blood, that she won't revert to slashing her arms and maybe escalating to even slashing her wrists, which could have major medical problems.
We can't tell what's going to happen in the future, so we're right at this point. She's safely doing these things, and so that's important to know that she's safe right now.
Thank you.
Excuse me, Counselor, just to follow up on that, would you say there's a predictable deterioration of her condition if she does not go treated within next year, 6 months?
Can you say that again? Sorry.
Would you say that there's a predictable deterioration of her mental condition if we did not treat her?
Yes, that could very well happen. There were no alternates for treatment that was considered, and the state did not try hard enough to find a less restrictive alternative than the state mental hospital. And with that, for the foregoing reasons, the decision of the court should be reversed. I yield the rest of my time to my co-counsel.
May it please the court, my name is Kate Reed and my co-counsel is Bailey Furman, and I will be presenting the second issue today, which was there enough evidence in the record to support the district court's conclusion that Harriet can be involuntary medicated if needed? I'd like to first clear up a few questions. There was one question about the testimony, and what we have found on the appellant side is that the district court's, in the district court, the testimony from Dr. Grace Spirit was invaluable because she said that the medication may be necessary and not would be necessary. Also, there was question about pulling back into the fact pattern and looking for questions about that, and the fact pattern is beneficial but does not contain enough info to conclude for the involuntary medication or involuntary commitment order. And
So are you arguing that the fact that this woman believes that there's vampires out there, she's attacked now 2 people, that shouldn't be, I mean, that's not sufficient to commit someone if they're unwilling to be treated or able to be treated?
we believe that that is beneficial, but we believe that there's not enough evidence other than that to conclude that she needs this. As Dr. Grace in her testimony said, she said it may be not necessary and not would be necessary. But today I'll be presenting the second issue, and Harriet deserves the effort needed to find a less restrictive and terrifying alternative for her, as mentioned in MCA 53-21-127, Section 5, Subsection 3. The court shall use the least restrictive alternative necessary to protect the respondent, and the key words in that Montana code are protecting the respondent. It's our duty to protect Harriet. Harriet Spetz, being a citizen of Montana, has the absolute right of due process and freedom. It's plain that Harriet has a mental disorder, as she is a diagnosed schizophrenic, but there's insufficient evidence to support the necessity of involuntary medication and to support the bare bones order that is forced upon a woman merely because of a hypothetical. We must also take into consideration, in the case of RH 2016 that referred to MCA 1-4-101, that states the plain language of the statute, as it says the order for medication must fall under is necessary and not may be necessary. And once again, this also rendered Dr. Grace Spirit's testimony invaluable, as she stated it may be necessary. Being in a court of law, we must see that we must strictly adhere to the statute and see a clear error that is legally significant. There must be no hesitation. Also, like in the case of RH and P13, it was undisputed that RH had a mental disorder, and the appellant side would like to make it completely clear that Harriet had a mental disorder as a diagnosed schizophrenic. However, RH was unable to meet her basic needs and had poor decision-making. Harriet had stability and only had her uncontrollable outbreaks when her medication was taken and not replaced. An involuntary medication order like this one does not meet statutory standard or improve Harriet's condition. Harriet's condition only will and can improve when an alternative found, such as the proposed nursing homes or unexplored medications past the 14. Someone's sanity and potential life stand in the balance, and Harriet, as an established artist and business owner who has financial stability and was able to control her condition well on proper medication, deserves the rare freedom of self-care that comes from a shackling mental disorder. Harriet did not abruptly decide to stop taking her medicine that was supplied to her, but rather it was taken from her, and no further alternatives have been explored or tested beyond the 14. Harriet did not intentionally do anything wrong. She can't help it when her medication is taken from her. However, Harriet shows her independence by attempting to manage her disorder.
Counsel,
Yes.
let me stop you and rewind a little bit. Sorry, just baking in my head for a minute. So my concern here is we've tried 14 medications. She had a great one. FDA takes it off the market. We've tried 14 different medications in the interim, and we haven't found a winner yet. She has vocalized that she's not going to take anything that's colored. Here's my concern. As we keep exploring new medications, I'm worried that we're going to get to one that is a colored liquid or somehow colored IV. I think she said she also wouldn't do. And we're in a situation where now we have to involuntarily administer these medications. And I know that's a little bit speculative, but that's my concern. Can you allay my concern at all?
In the fact pattern, it said that it was very unlikely for Harriet to have to take a liquid medication. And, can I finish my statement? Okay. And the hospital said it was very unlikely, but it was the most convenient for the hospital at the time. So basically it means that the patient needs were put aside and the nursing home options were also mentioned. So basically what our side is saying is that we're giving a dangerous precedent to the government of too much power for individual lives.
Thank you very much.
Thank you.
May it please the court, my name is Delaney Pruitt, and seated to my right is my co-counsel Maria Lovely. Thank you for being here today. Today I will be addressing the issue of whether the findings of fact and conclusion contain all the findings and evidence necessary to support Ms. Beth's involuntary commitment.
Council, let's cut to the chase. Sub 8A in 5321-127 is pretty clear. A detailed statement of the facts shall be made by the district court. Can you show me in this district court order where there's a detailed statement of facts sufficient to commit someone and take away a fundamental liberty?
Yes, sir. If anybody has the finding of facts record and would like to follow me, please do so. If not, I'll try and make it as clear as I can with the points. On page 1, paragraph 1 in the introduction, it says, according to Dr. Spirit, Harriet Spetz suffers from a mental disorder, schizophrenia, paranoid type. She needs to be committed and is unable to care for herself because of her mental disorder.
How is that not conclusive?
This statement is just enough to look into the record and trigger the doctrine of implied findings as defined in paragraph 29 of case RWK 2013.
Where is the doctrine of implied findings in the statutory code? Statutory code is really quite clear. In ordering commitment pursuant to this section, the court shall make the following findings of fact. Not the court can infer from testimony. This is supposed to be in the written order. How is this order sufficient?
Just this quote right here can trigger the doctrine of implied findings, but there are about 4 more quotes that line up with the law 53-21-126. The next one would be that she needs to be involuntarily committed because she is unable to care for herself and lacks the ability to provide herself with the necessities of life. The necessities of life, according to that law, would be the respondent's own basic needs, food, clothing, shelter, health, or safety. So she has to be in violation of any one of those, not all of them. She is in violation of her own personal health because she is drawing her blood without a doctor present and hoarding it in her freezer to create vampire traps because the angels told her to do so. And if she isn't and she's also, according to 53-21-127.
I guess what I'm saying, counsel, is that this is not in the district court's order. These facts could have been found by the district court as the arbiter of the fact that situation, or as the arbiter of the factual situation here. But the district court did not make these findings of fact. All we have are that she's a young woman, lives in her own home, lives alone, etc. There is not enough here to find us, correct?
Correct, just based off of the findings of fact. But in the case... In case RWK 2013, Montana 54, in paragraph 29, it states that the doctrine of implied findings is defined as any findings not specifically made but necessary to the court's determination are deemed to have been implied if supported by the evidence. But this is, so that first quote right there falls in line with that definition. So it triggers the doctrine of implied findings, which provides the court the capability to look into the record more for the facts to involuntarily commit misspets. Does that answer your question entirely, Justin?
We'll see.
So, unlike case LLA, where the judge simply referred to the medical diagnosis as basis to involuntary commitment, Judge Russell, the judge on our case, made specific findings regarding the attacks on August 15th of 2016, along with Ms. Spetz's personal health violations of drawing her own blood. You, the court, can find an example of these health violations in the record of facts. When Ms. Spetz began to look at YouTube tutorials on how to draw her own blood, and then began to hoard it in her own fridge at her home to make vampire traps around her property when she caught neighborhood cats and then vampire tested them and released them. Also, in case SM 2014, Montana 309, Judge Ortley was the judge on that case, and he provided the court with enough facts to apply the doctrine of implied findings as defined in RWK, and our Judge Russell did the exact same thing as Judge Ortley in SM. Another quote from the findings of fact is, "The least restrictive treatment option that would provide her with adequate treatment and protect her would be a commitment to the state mental hospital. She needs constant supervision to ensure her needs are met." And that is on page 2, paragraph 3 of the introduction. Since we are now able to look into the record, the supporting evidence of this quote comes from page 2 of the record. It is stated that Ms. Spetz began to deteriorate and that her life basically revolved around vampires and what the angels told her to do. So once the angels told her to attack a man who was wearing a red shirt and black shorts, she did so on August 15th of 2016. Now that falls in violation of the law 53-21-126, Section B, where she caused injury to others, Section C, where because of a mental disorder, there is an imminent threat or injury to respondent or to others because of the respondent's acts or omissions. And then Section D of that same law says whether the respondent's mental disorder is as demonstrated by the respondent's acts or recent omissions will, if untreated, predictably result in deterioration of the respondent's mental condition to the point at which the respondent will become a danger to self or to others, or will be unable to provide for the respondent's own basic needs of food, clothing, shelter, health, or safety.
I guess, counsel, I'm still struggling with this. I don't disagree that she, right, if we look at the record, we look at the entirety of the record, right, could she meet all these potentially, right? That's your argument, clearly. But we're dealing with a constitutional principle here, specifically a couple of them, right? We're saying that this woman, whether or not this woman should be deprived of a fundamental liberty, right? That which is to pursue life's basic necessities, right? And we're only going to take that away unless we have due process of law for her, right? So we have a hearing, we have testimony here, but then the district court, when the district court issued its order, literally did exactly what we criticized in In Re LLA as quite simply merely reciting the language of 126. Did not address any facts specific to LLA. I'm going through the conclusions of law here. The state has proved by medical certainty that HS suffers from mental disorder. That's just reflecting the statute, right? I mean, we're taking away her fundamental liberty if we agree with your position, and it looks like they haven't done enough analysis to actually say that that should be done.
Judge Russell left just enough information so that the court, the court, can look into the record and reference that as due process of law to involuntarily commit Ms. Spetz. It also has a testimony of Dr. Spirit, who stated that she does suffer from schizophrenia paranotype, so it has been affirmed that she does have a mental disorder. And also in the findings of fact, it says, however, she has stopped sleeping, caring for herself, and is currently a risk to herself and others. So therefore, just saying that she's a risk to herself and others comes in violation of that law on Section B and C.
It seems very conclusive to me.
Counsel, let me switch directions a little bit on you. And this may be something your co-counsel is going to talk about, and please tell me if it is. But even if we do reach back into our record and we look at all the evidence from the hearing, Why is the Montana State Hospital the least restrictive means of caring for our plaintiff here?
In the findings of fact, it only states that the state mental hospital attempted to place her in nursing care facilities. 2 of these facilities could have accepted her. The only facility available to care for her is the state mental hospital, and the reasoning for this is that because she lacks the ability to provide for herself and needs constant supervision. And Dr. Spirit works for the mental hospital, so she would know that they are underfunded and overworked and have a lot of patients.
Is that in the record?
No, sir, it is not. It is an assumption. But I do not believe that Dr. Grace Spirit would have testified that the best place for Harriet would have been in the state hospital if she wouldn't have truly believed it.
Thank you, counsel.
I yield the rest of the time to my co-counsel.
May it please the court, I'm Maria Lovely, and I will be addressing the second issue in this case regarding the involuntary medication of Ms. Spetz. The district court correctly held that Harriet can be involuntarily medicated if needed. As of today, Spetz refuses to ingest any colored liquid due to the fact that she believes it's vampire's blood. The record states that even at the state hospital, Ms. Spetz still refused all colored liquids. Without proper medication, Spetz is a threat to both herself and the public. Turning to the Montana Code, MCA 5321-193, subsection 6 states, the court may authorize the chief medical officer of a faculty to administer appropriate medication involuntarily if the court finds that the involuntary medication is necessary to protect the respondent or the public or to facilitate effective treatment.
All right, counsel, I'm going to stop you right there. So my reading of INRATE RH says that when there's no history of noncompliance with taking the medications, and when we're basing our decision on, or when the district court bases their decision on involuntary medication on the chance that they might in the future become non-compliant, I mean, that sounds like the exact situation we have here. She's always complied with taking her medication. And we're worried that because she says she doesn't like the vampire blood meds, the colored liquids and the colored IVs, that one day in the future she might become in non-compliance. And we found that to be insufficient in RH. Could you distinguish that for me?
Yes, thank you for bringing that up. In order to facilitate an effective treatment, it is imperative that the chief medical officer has the ability to involuntarily medicate Spetz if needed. And the slight chance that out of the few options we have, a non-colored liquid treatment is found to be effective on Harriet, there's a high possibility that she will receive a new notion that will not allow her to have, say, medicine in the form of pills. She's very unstable and basing all
Do we
of her
have any evidence that she's going to continue to deteriorate in that way? I mean, it seems like you're asking us to conclude that she's going to add things to her list of I won't do that.
She started with her vampire traps only needing a little bit of blood, and then the angels told her, oh, you need more blood, you need more blood. So she began drawing her own blood. I think that is evidence enough to show that she is unstable and bases her decisions off of these things that these people are telling her, and we have no idea what's next.
Counsel, how does, like, we're going to be deciding whether or not involuntary medication should be blanket, applied here prescriptively by this case. If we're, I mean, why should the district court from here on out, if we allow this in this case, just constantly not, or sit there and constantly just say, if they need to be involuntarily medicated, they can? I mean, this kind of seems like a slippery slope to me. We don't have specific facts that she's actually refusing any medication right now. Nothing in the record for that. There's nothing in the district court order on that. He's just prospectively saying you can involuntarily administer it. Why shouldn't district courts just do that from now on? Leave it totally in the hands of the medical professional.
Ms. Spetz has been a harm not only to herself, but the public as well. And in order, she has shown a history of medical compliance, but in order to find a medication that works for her, because a lot of them don't, 14 of them did not, they need the ability to try medications that might be a colored liquid. If nothing's working, if she's deteriorating and getting worse, harming herself even more and the public even more, then
So at
it's
that
in her
point, why
best
shouldn't the
interest.
medical professional and the state come back to the district court and say, we need an order for involuntary medication? Why do we have to do it prescriptively up front when there's actually no evidence thus far that she's refused any?
Because she refuses, she has and she will refuse to take colored liquid medication, and that may be the answer of what she needs.
Again, maybe.
Counsel, how does that work with RH's holding that we have strict adherence to the statute, when our statute requires that it's going to be necessary, not may be necessary sometime in the future?
When Judge Russell said it may be necessary, he was speaking to the future, and everything in the future is hypothetical. I understand that. What's not hypothetical is the fact that Spets will not take colored medication, and having so few medications properly work on her means the chances of her having to take a colored medication are high.
Okay, but the holding still says that strict adherence to the statute is required, and in this case, we didn't have that in the district court order.
Yes, I think we also need to keep in mind that she can change her mind very quickly, and that she is unstable and does not realize what is best for her and for the public. It is our job to provide her with adequate treatment and protection because she is unable to care for herself or provide herself with the necessities of life. And when thinking of Miss Spets and what is the healthiest, safest for her and all the people she believes to be vampires, it is quite clear, may I finish? That just as the district court has previously concluded, it is most necessary to authorize the chief medical officer of the state mental hospital, if needed, to involuntarily administer medication to Harriet Spets to facilitate treatment. It is crucial that you affirm the district court order. Thank you.
May it please the court, my name is Kate Reed again, and once again to clarify, my co-counsel's name is Bailey Furman, and I will be delivering the rebuttal. On their first issue, when asked about the detailed fact pattern, the appellees could not prove that there was a detailed fact pattern to follow the statutory requirements. As I previously said, in MCA 1-4-101, that was previously mentioned, the plain language of the statute was not met. And if there was hesitation on whether or not this order is necessary, then the court needs to take a second look on a woman's liberty and a woman's freedom. We are giving government a dangerous precedent over individual lives who don't actually want to hurt anyone. Harriet was consistently medically compliant and only requested they avoid liquid-colored medication. And as my co-counsel stated, it's perfectly reasonable to ask for the least restrictive alternative, as you can ask if you are afraid of needles, you can ask for medication that does not involve needles, or if you're allergic, you will not take that medication. It's perfectly reasonable for her to ask for the most comfortable alternative. In MCA 53-21-127, also previously mentioned, it clearly says that the code is our duty to respect the respondent. It's our duty to duty to protect Harriet, and if that means that we're going to find something that's more comfortable for her, then we should do that. Also on point 1, they stated that Dr. Gray Spirit wouldn't have sent her to the state hospital if she didn't find it necessary. But Dr. Gray Spirit said it may be necessary, and so did the judge, which once again does not follow the statute, as it said that it is necessary. On their second point, it's based merely on a hypothetical, and they said they believed it could snowball, but once again, this is a slippery slope argument. There is no guarantee in the future that Harriet is going to deteriorate more, and there's no evidence that she has deteriorated more from her episode. And they stated it's not a hypothetical that Spets will not want to take a colored liquid medication, but once again, Spets asked what's best for her, and as a court of law, we need to be looking at what's best for the respondent, which is the most comfortable alternative, which could be a nursing home, or there could be more work put into finding an alternative. And I know that 14 were already explored, but we can explore beyond that if it means that we are protecting the respondent.
I mean, counsel, at one point, right, don't we have to take into account the needs of broader society?
Yes.
We've had one person at least stabbed, another person attacked, attempted stabbing, right? At one point, do we commit her? Is
Well,
this not enough?
I do believe that Harriet having that episode was not good for public safety. I believe that if we did find that less restrictive alternative, which could be a nursing home, which could be put into place immediately, then those episodes would not continue and her condition would improve. And once again, that is a hypothetical, but we can safely assume that if she was in a more controlled environment or had a more controlled medication.
So you're conceding she should be committed?
No, the nursing home is the less restrictive alternative. The mental hospital is the restrictive. It's separate. Today we hold a woman's life in our hands, a woman with an established career who happens to be laid with the heavy burden of a mental disorder. Harriet is misunderstood and only asked for the comfortable option for her, which, as I stated, could be more medication, a nursing home. For the foregoing reasons, the decision of the court should be reversed. Thank you. I will give the rest of my time to the court.
Thank you, counsel. Before we do adjourn, do the clerks have, well, the justices have any comments or advice or anything of that they'd like to give to the attorneys?
Yeah, I do. I can start. Took notes. First of all, I want to say I'm really impressed, guys. Really impressed. And I won't take up too much time. I'm just going to kind of hit the highlights, what I consider to be the highlights for everybody. I'll start, and I apologize if I get your name wrong. Bailey? You were first, right? Yeah. I feel like we really hit you with questions from different parts of your argument and sort of pulled you out of the flow of your argument. I know from experience that is one of the hardest things to deal with, getting taken out of your sort of flow and then having to find your way back. I think you did a really good job with that. Moving on to Kate, you started out by answering the questions that we had asked Bailey, some of the questions. You sounded like you had a prepared response. You were right out of the gate with it, nailed them. I thought that was really compelling, so good job with that. Moving over to Delaney, is that right? Okay. I think you handled Justice Stockton's question very well. It went on and you kept with it and you didn't try to redirect or anything else. You answered his question, and when he kept pressing you on it, you continued to answer. I think that was the right way to handle that. Good job. Also, you had a great command of the cases and the facts. He asked you, I think at one point, is that in the record? And you said no immediately. You knew it wasn't in the record. I think that's great that you had that right off the top of your head. Maria, I think you got beat up the most. Sorry about that. It was a tough issue for your side. I think you handled it very well. Again, I think it's just a tough issue for that side, and you stuck with it. You didn't kind of wilt in front of, I think all of us sort of piled on at one point. You handled it. That's really, really tough to do, so very good job with that. That's all I had.
So yeah, I'll go in order. Bailey, yeah, exactly what Tom said, throwing you out of your argument. That is going to be one of the things that any court is going to do. There's certain things that the justices want to talk about. And the strategy, the key to be giving an effective oral argument up here is going to be answering their question while still getting in the points you want to make to the court. And you did that well. I intentionally asked that question out of the gate for most of you to do that to you. Responding to that, all four of you did that really, really well. Kate, like Tom said, that response coming in to help your side, that's excellent, right? When you have two people arguing, oftentimes it's just one from each side who argues. You have a chance to sit back and make some notes, and that was really, really smart. Because sometimes when you're sitting up there and you're arguing, it's really, really hard to get back on your feet. Your co-counsel sitting at a table, has their books, has their notes. That was super smart, helping her back her up on those arguments. Delaney, right? Did I get that right? Yeah. I hammered on that because I think this is one of the huge weaknesses in this whole case. And the state always has an uphill burden here. So that's going to be the exact question that when you're trying to take liberty away from someone, that is going to be the primary question before the court. And that's why the court says strict adherence and fundamental rights and whatnot, right? So excellent on responding to that. The citations to the record were phenomenal. If you're unable to do that, it adds a question into a justice's mind that says, well, gosh, does she actually know what's in the cases? Or does she actually know what's in the record? Can I trust what she's saying right now? Having that complete grasp of everything is what gives the court a lot of confidence that your argument is sound as well, right? It's kind of a meta level of your argument. Phenomenal job. Maria, right, last? That is the weak point of the state's argument. So excellent job handling all three of us piling on there. It's not an easy thing. You had the cases down, you had the statutes down, that was well done. Overall, like, y'all did phenomenal, so well done. This is not easy at all, and I've seen like 30-year attorneys stand up there and just shake, so phenomenal job.
So great job overall. I was really impressed. Like Tyler said, there are attorneys who don't do as well as you guys did. So I have a couple things for each of you. Bailey, I thought you did a really good job of taking a minute when you needed to look up your notes. I have heard attorneys put their foots in their mouth before when they say something and then realize they misspoke. So the fact that you were willing to take a second, look it up, and then answer our questions thoughtfully, I really liked that. Kate, I really liked that you used Tyler's phrase back when you came up. I think you said the slippery slope argument. Yeah, that was really good. So I just wanted to point that out. I know I would like to hear my own words repeated back to me. So I just thought that was really good. And then Delaney, yeah, yet again, you knew, I felt like, and this might not be true, that you knew the cases and the facts better than anybody and had no problem rattling off stuff to us, which was very impressive. And then Maria, sorry that we were so aggressive, but you did a great job not backing down and sticking with your argument, even when I feel like we were trying to make you question your own argument. So that was really great.
Thank you.
Yeah.
All right, thanks again. And we'll now take this hearing under consideration. The matter's under advisement. This hearing is now adjourned.